Hi, my name is Lizzie Chan, and I'm a member of the CPR Institute's Young Leaders in Alternative Dispute Resolution Steering Committee. I am delighted to host today's episode of the CPR Y-ADR Corporate Counsel interview series. The Y-ADR seeks to educate the next generation of leaders in the ADR field on the full spectrum of dispute prevention and resolution mechanisms, and to provide an insider's perspective on how CPR's community of in-house counsel, external counsel, and other experts in the ADR field are using these mechanisms to manage conflict to enable purpose. And as part of this goal, in this interview series, I am speaking to corporate counsel and companies all around the world about their experiences with ADR and to ask them to share their career advice for young practitioners. Today, I am delighted to welcome Patrycja Kolwas, who is Senior Disputes Counsel at COFCO International, based in Geneva. Hi, Patrycja. We're delighted to have you here today.
Hi, Lizzie. Thank you very much for the invitation. I'm happy to contribute to your project, and it's my pleasure.
We are so lucky to have you. And my first question for you is, how did you come to become an in-house lawyer focused on dispute resolution matters?
Well, I'm a litigation lawyer with more than 15 years of experience, and ever since I remember, I wanted to do this. So I started working in a law firm when I was a student to gain some practical knowledge and to see how legal concepts work in practice. And after my studies, I joined a corporate and litigation arbitration department of an international law firm, where I spent a few years advising my clients on complex commercial disputes and representing them in proceedings before courts and tribunals. In 2016, I joined COFCO International in Geneva, where I'm a senior disputes counsel responsible for advising the company on disputes related matters and including arbitration and cross-border litigation. In the meantime, I also completed an LLM program in international dispute settlement in Geneva. So as you can see, my entire life is related to dispute resolution, and I must say it's wonderful to earn a living doing something that you love.
I'm so glad that ADR has been a fantastic career for you. I was wondering, what were your first impressions after transitioning from private practice to your in-house roles?
Well, I didn't expect that it would be such a big change. And what struck me the most was how my perspective has changed. So when you are in a law firm, you advise your clients from the outside, and you don't see all the aspects of your client's business and their day-to-day problems and how their company operates. So usually you also don't participate in internal meetings with the management, with the commercial team, with other functions. And you know, when you work on a case, external lawyers usually receive information related specifically to that case, and based on that, they defend the case. So you can say that you watch the situation from a distance. And it's quite different when you work in-house, because then you are a part of the organization. Your clients are your colleagues, and you're invited to participate in various meetings, various trainings. Thanks to that, you know the business of the company, the business the company does, and you can be a part of the decision-making process. So being in-house counsel allows to better understand the problems and the issues that the company is dealing with, and of course, adapt your legal advice to the company that you work for. So you can say that your legal advice is tailor-made.
It's so interesting to hear about your role as the in-house counsel and how embedded you are in the company that you work at. I was wondering if you could share your perspectives on the importance of the role of the in-house counsel in managing disputes.
That's a very interesting question. Thank you for asking this. And I would say that the role of in-house counsel is not that much visible, but it's essential. An in-house lawyer has an important role to play directly or indirectly at every stage of the life cycle of a dispute, and even earlier when a dispute settlement mechanism is negotiated in a contract. So, and I'll give you a few examples of how the in-house lawyer can contribute to the management of a case in a moment. But before doing that, I would like to make a general comment. Over the last few years, the role of an in-house counsel has changed, and it is now more than ever expected to be a partner to the commercial team rather than a back office function. And in broader terms, the role of the legal team is to support the various functions in running the company's operations in a smooth way, and of course, highlight potential risks and exposures. At the same time, the legal team is expected to propose solutions to mitigate those risks. So to that end, the legal team should be involved not only when there is a problem, but also in the day-to-day work of other teams. And there are at least two benefits of this setups. So first of all, in-house lawyers have a deep understanding of the company's matters, and they are ready to immediately step in when it's necessary. And recently, I read an article written by Claudia Salomon for the ICC Bulletin. In this article, she pointed that these days, in-house legal team is expected to serve as a value center rather than a cost center. She also highlighted the increasing role of in-house lawyers in the arbitration process, and she gave a few ideas on how to improve it. So, but going back to your question, I will give you a few examples of how in-house lawyers add value to the management of disputes. And number one is negotiations. So first of all, in-house legal team should be involved in negotiations around dispute resolution or liability clauses in contracts. That allows to avoid disputes at the early stage and also other issues which may be problematic later in the course of the proceedings. So, for example, inoperative arbitration clause, ineffective indemnity clause, etc. Number two is pre-dispute phase. And usually at this stage, the in-house legal team is already directly or indirectly involved by the commercial team. That involves sharing correspondence, copying the legal team on emails, discussing the positions, informing the legal team about pending discussions. And that allows the legal team to prepare the ground for further legal actions if that's necessary, right? And step in when the situation requires that. Number three is dispute phase, and we could definitely spend hours discussing about the role of in-house counsel at this stage. But to make it brief, I would say that this is the moment when the legal team really takes over the file and prepares their analysis. And of course, before anyone moves on with the case, it's important to understand the position and arguments of your company, of your counterparty. And it goes much quicker and easier if your legal team is already involved. Then, of course, before starting the proceedings, in-house legal team will be involved in selecting an external counsel, experts, arbitrators, collecting evidence, preparing the file, asking questions to other involved members of the team. And Then in the course of the proceedings, of course, if in-house lawyers will manage external lawyers and provide them with instructions, actively participate in preparation of the strategy and arguments. And here, if I were to give a tip to external lawyers, I would tell them to work closely with an in-house legal team, because they can be a very good source of information and have a deep understanding of the company and of the case, of course. Finally, I would say enforcement. And I would say that this phase shouldn't be underestimated, because the post-award phase is very important to the business. So as you can see, there is plenty to do for in-house lawyers at every stage. And I think that this involvement will only increase. You can already see that many companies have dedicated litigation teams to resolve disputes.
As an external counsel, I really appreciate your insights about how important it is for us to work with in-house counsel every step of the way to really understand the client and its commercial objectives, and especially when we're advising the client on how to proceed on a particular dispute, that we do so in a way that aligns with the commercial objectives of the company. I'm also really glad that you mentioned Claudia Salmon's article on in-house counsel being value centers. I really appreciated her insights as well. I wanted to return to one of your points about the importance of the quality of the contract, and in particular, the dispute resolution mechanism as a way to prevent disputes or resolve them efficiently. I was wondering if in this regard, you had any tips?
I will not surprise you if I say that everything depends on the circumstances, right? So, but I think that there are a few checkpoints that I can mention. So, first of all, I would start with a careful review of all terms of a contract for which you are negotiating a dispute resolution mechanism, and that refers to the subject matter of a contract. It's it's important whether this is a general services agreement, or maybe this is an agreement already which requires technical or very specific knowledge. I would think about the parties to the contract and where they are based, and what the governing law may be because of that, and if there is already a track record of your previous cooperation with this counterparty. Then I would also look carefully at clauses which may generate claims. So think what kind of claims may arise out of a contract, and whether this is something which should be already addressed in a dispute resolution clause. So for example, I would check indemnity clauses, I would check limitation periods, confidentiality clauses, and so on. Another point is that I would check if there are related documents which already include a dispute resolution mechanism, so that you can avoid the situation where you have two different dispute resolution clauses which may cover the same dispute. And of course, I would think whether you need to apply for interim measures, and where you may need to enforce any decision granting interim measures. And of course, the last but not least, enforcement, which, as I said, is very important. I would consider where you are going to enforce your award, and whether this award may be easily recognized and enforced there. So these are some basic points, and of course everything depends on a case, on circumstances, and on your counterparty.
At the beginning of this interview, you said that you've loved your career at ADR. And I can tell through the answers to my questions that you've gained so many interesting insights into the ADR process. And I'm sure that many young practitioners watching this interview are interested how they can have a career like yours. So what is your advice for those looking to go in-house?
I would say go for it if you can. It's a great experience to see how the company works from inside, and I have a privilege to work with very talented and experienced lawyers. So do it if you can. But if you really ask me about any tips, maybe I would give you 2 or 3. So first of all, I would advise those looking to go in-house to learn as much as they can about the company they will work for. So it's about its history, about structure, functions, reporting system, adopted policies, governance rules, whatever they can find in the public domain. Because that will already help them to get a better understanding of the company's needs and issues that may arise. Secondly, when you are being interviewed, ask what a success in this role looks like. It should give you a good perspective of what is expected of you and how important the role of in-house counsel is in a given company. And finally, once you are an in-house counsel, I would tell them to invest time in building a relationship with external lawyers in a day-to-day work, not only when you're working on a specific case. As I said before, in the in-house role, you will have to work hand in hand with external lawyers and provide them with instructions, ask for legal advice. To make that work, it's important that the outside counsel understands the background of the case, expectations and goals of the company. So, for example, after sending your message asking for a complex legal advice, give him or her a call to discuss whether he or she has any questions or comments. And I'm sure that will allow you to build trust and good cooperation in the team, because, at the end of the day, you are one team, although with different tasks. And that will also help you get the legal advice, which I think will answer your questions and will also save you money.
It strikes me that the advice you have for practitioners who want to move in-house is also directly relevant for external counsel. Things like really understanding the company, reading publicly available documents, and also maintaining a very good ongoing relationship with in-house counsel is so important for external counsel. I want to ask you a specific question about bidding for work. What's your advice for external lawyers who are trying to pitch to a client and to win work with that client?
Yes. So one of your previous guests said that one thing that he wouldn't like to receive is a general leaflet and about the law firm. And I agree with that. And the reason for that is very simple. At the end of the day, it's not the law firm that really matters, but the team that will be working on the project. And so I would focus on that to show how much they fit into the project and how they can contribute to the outcome of the case. So I think that's an important part of any offer. Then I would also, suggest to ask as many questions as you can about the project, about your client, about the goals, any expectations. So then you can reflect this in your offer. And the last point I would make is the attitude. Show that you care and present a hands-on approach. So, for example, never miss a deadline to file your offer.
based on our interview, I know that you have seen so many different disputes in different contexts. And also I was wondering, since your first contact with ADR, what has changed?
I'm very happy to see more diversity in the arbitration community and practitioners coming from different countries, regions, and cultures. And I think that's particularly visible when you're an in-house counsel, where you have to work in different jurisdictions with lawyers from different jurisdictions. But then I'm also very happy to see that there are various initiatives and organizations bringing together women and promoting them in international dispute resolution. And that's really encouraging. And one more thing that really makes me happy is that I see more initiatives by international arbitration bodies involving in-house lawyers. And for example, your interview series with the in-house corporate counsel is a great example here, and that's really amazing what you do. Then I would also mention the Institute for Transnational Arbitration, who created the in-house counsel committee, which is a platform for in-house lawyers in the international arbitration to share knowledge, collaborate, organize events which are specifically tailored for in-house lawyers. And another example is the user council created by Swiss Arbitration Association, which is also a platform to formulate and channel user demands. And also the platform allows them to benefit from exchange of experience and knowledge. So in this context, I already mentioned the article written by Claudia Salomon, but she also in her article presented 7 ideas on how to increase parties and in-house counsels' involvement in international arbitration and how to make sure that that their expectations and the arbitral process are aligned. So I will definitely follow the ICC's initiatives in that respect.
We're so privileged to have you on this interview series and to share your insights. I think that, and I hope that many junior and mid-level practitioners especially will get a lot out of these interviews, and to get practical advice like the ones you've shared today about how we can best work with in-house counsel to resolve disputes or to avoid them entirely. I'm also delighted that you mentioned the issue of diversity and how important it has especially become, how visible that issue has become more recently. Our audience may not know this, but you and I met at a gender diversity initiative that was started during the pandemic, which is the Mute Off Thursdays program, which recently won the GARA Diversity Award. And that is fantastic for connecting women in our field. My last question for you is a big one, and that is, what would you say to your younger self?
Wow, so many things, I guess. But there is one piece of advice that I have received recently, and I very appreciate it. It's don't be too strict to yourself, because there is always someone who will do it for you. So, of course, be demanding of yourself and work hard, but don't underestimate your skills and don't doubt in your knowledge.
I love that advice so much, and will seek to apply it in my own life. Thank you again, Patrycja, for your time and for sharing your insights today. We really appreciate it, and I look forward to working with you on the CPR Y-ADR Steering Committee. And I thank our audience for tuning in.
Thank you very much, Lizzie, for the invitation and for your time.